Does a surviving spouse need probate? If your spouse has recently passed away, you might be wondering if you need to go through probate in order to inherit your spouse's property. The answer to this question depends on how your spouse's property was titled and the value of your spouse's solely owned assets. The first question is whether your spouse's assets are subject to probate administration in the first place. Some property simply doesn't have to go through the probate process. Common examples of non-probate transfer assets include 1. Property that's held in trust. 2. Jointly owned assets that have a right of survivorship, such as a bank account or real estate. 3. Payable on death, POD, or transferable on death, TOD, accounts that have beneficiary designations. And 4. Proceeds from life insurance policies, which generally have beneficiary designations as well. Also, in California, our probate code establishes a dollar threshold for when probate's required. Does a surviving spouse inherit everything? In California, a surviving spouse does not automatically inherit everything from their deceased partner. However, it's certainly possible that a surviving spouse may inherit everything, and in many cases, in fact, they do. Your spouse's non-probate assets are going to pass as follows. 1. Trust property is going to be distributed to the named beneficiaries under the terms of that trust instrument. 2. Jointly owned assets will be automatically inherited by the surviving joint owners, provided that there is a right of survivorship in those documents. 3. Funds from POD and TOD accounts, as well as life insurance proceeds, will be distributed to the designated beneficiaries, provided beneficiaries have been named. However, keep in mind that if you're not the beneficiary or joint owner of a non-probate asset that your spouse obtained during your marriage, California's community property laws may entitle you to inherit a portion of that despite the beneficiary designation or the co-owner's right of survivorship. It's very complicated and is something that should be reviewed with a probate litigation attorney to ensure your rights are protected. When it comes to probate assets, what you'll inherit depends on whether your spouse had a will or trust, whether you and your spouse signed a prenuptial or postnuptial agreement, and whether the property was acquired during or before your marriage. What is a surviving spouse entitled to? A surviving spouse is entitled to at least 1/2 of the marital community property. However, they often receive considerably more based on the terms of their spouse's will or the state intestacy laws. Because California is a community property state, the law presumes that all the assets you or your spouse acquired during your marriage will be presumptively community property, no matter how titled. Absent a prenuptial or postnuptial agreement that states otherwise, when one spouse passes away, the surviving spouse is entitled to at least 1/2 of the community property, since each spouse owns 1/2 of all property acquired during the marriage, regardless of which spouse purchased it. If your spouse leaves behind a valid will, their probate assets will be distributed according to their wishes as outlined in that document, again subject to some of the community property protections we discussed. If there's no will or the will is found to be invalid, then California's intestate laws are going to determine how the assets are going to be distributed. What happens if you don't probate a will? If your spouse dies and you don't probate their will, it can create serious issues. When you fail to probate a will, the deceased person's probated assets cannot be legally transferred to their beneficiaries or heirs. Instead, any property that's solely titled to your spouse will remain in their name and not yours or the other heirs and beneficiaries, including vehicles, real estate, etc. This means you won't be able to sell, mortgage, lend against, or rent that property. You also won't be able to renew registration for vehicles titled in your spouse's name, which can lead to trouble if you're driving one of those vehicles. If your spouse has passed away and you're wondering if probate is necessary for you to inherit your spouse's property, the best thing to do is to consult a probate litigation attorney. A qualified probate litigation attorney is going to be able to help you determine if probate's necessary in your case and advise you on how best to proceed. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email, or schedule a free consultation at rmolawyers.com. Thanks for watching.